Here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the incredible William Porter, a California construction lien law guru. Today's webinar topic is Statutory Construction Releases, Best Practices, and the Gotchas to Look For. So without further ado, I'd like to introduce the fabulous William Porter.
Wow, what an intro that was, Jesse. Thank you so much. It's a total exaggeration, but let's just do our best with this today. I have been practicing construction law for the last 30 plus years, and so I do have some good knowledge, and I want to share it with you. So let's roll into this. We're going to try to get through this in 20 minutes. If you have any questions, go to the chat box on the right, and then at the end we're going to answer those questions. Oh yeah. Don't include company names and stuff, for the privacy of those companies, because then they'll hunt you down and sue you for defaming them or something. All right. And so we're going to talk about broad concepts. There might be, exceptions to this if you get deeply into the law and case law. But most of the things we're going to discuss today are pretty straightforward. And for California, they're all statutory. And so you can look up these releases, the 4 releases we're going to discuss today. You can look them up in the Civil Code. Okay, let's talk about using the releases. There are 4 releases, and they each do a different thing. Okay, the 4 types of releases, 2 of the forms are conditional releases, and 2 of them are unconditional releases. 2 are for progress payments, and 2 are for final payments. It's very important that you use the right one for the right circumstance. And one of the things that happens, which is the kind of thing that can be a gotcha that gets you, is when someone asks you to sign an unconditional release in exchange for a check, because the check could bounce, all that. And if you have given an unconditional release, that means that you have released your claims to a mechanics lien, a stop payment notice, or a payment bond claim. And these are really important remedies for you, which are the subject of another webinar or several webinars we can do at a later time. And if you would like, if you want to look up the specific civil code sections that apply to this, you could just go online and Google California Civil Code and look up 8132 through 8138, and you will see these the language in these releases. And by the way, companies are not supposed to change the language in these releases. The language is supposed to be exactly as they're written in the statute. People try to change them sometimes to lessen the protections that you might have. Okay? All right. Okay, the 4 release forms. Okay, the first one, we're going to talk about the 4. Now, the first one is if a progress payment is only promised or it hasn't cleared the bank. Maybe you even got the check. Okay, and you're required to give a release in exchange for the progress payment, and they want you to sign a form. The form should be the conditional waiver and release on progress payment. Okay, it's conditional because you don't know if the check is going to clear, and even wire transfers can be, checks can be, they can bounce, they can be reversed, and even wire transfers can be rescinded. Okay, typically what people would say in that case is they'd call the bank and they would say, oh, I'm a victim of fraud, or they could say fraud, but it could be something as simple as a disputed change order, which they want to elevate and characterize as fraud. Okay, but anyway, you want to use an unconditional waiver and release on progress payment because the condition is whether the check clears the bank, and you don't know whether it's going to clear the bank or not. So you have to use a conditional waiver and release. Once the check clears, you can use an unconditional at that time. Okay, and then if the progress payment has been paid in full, as I just mentioned, then you would use an unconditional waiver and release on progress payment. You can see the Civil Code section there if you want to look it up. It just basically says, okay, hey, that check cleared. All right, next one. Okay, now we're talking about final payments. The earlier ones, and we're going to look at the actual forms, okay? But the earlier 2 were for progress payments that happen as the job progresses. And these last 2 forms are going to be the forms that are going to be at the end of the job, okay? And you're done with your work, you're getting paid in full, and you're going to do the same thing as you did before. If a check comes or it's promised and they say, sign this form and return it, and we'll give you a check, or here's a check with the form. You don't know if it's going to clear the bank. So you have to give a conditional waiver and release on final payment. Don't give the unconditional release until you have a cleared check. And then let's go to the next slide. Number 4. Now this is certainly for owners and general contractors. If you're a sub, it's the most important of all the forms, and it basically says, okay, we have been paid in full. And once you sign this, you are saying, okay, I've been paid in full. The check has cleared the bank, and we are done. Everything worked out great. I got paid, and basically to the general contractor and the owner, you're saying goodbye. And you're also saying that you're giving up your right to a mechanics lien, or to a stop payment notice, or to a payment bond claim. Now, I will say this. Let me add at this juncture, and I'm not sure if it's on a later slide. I don't recall, but these 4 releases, they deal with rights you have to mechanics lien, stop payment notice, and payment bond claims. But let's say you mess up with this thing. Let's say that you give an unconditional when you only should have given a conditional, and then the check bounces, and then shoot, I have actually given an unconditional release, so I have released my claim to a mechanics lien, stop payment notice, and payment bond, and that's unfortunate, but that's the consequence of having signed the unconditional when you only should have signed a conditional release. But even though it relates to mechanics lien, stop notices, and payment bond claims, it doesn't relate to your contract rights. So all of the forms we're talking about today, while they're evidence of you giving up your rights, it doesn't prevent you from suing for breach of contract. And at that time, you would say, yeah, I trusted them and I gave an unconditional release because, well, they tricked me into giving an unconditional release, basically, and I shouldn't have signed it. And I realized that now I lost my lien rights, okay? But I didn't lose my breach of contract rights. And I'm adding into there intentional or negligent misrepresentation for them fooling around and maybe even an action on the bad check, but just to say that if you mess up on these releases, you can still sue for breach of contract. Okay? All right, next slide. Okay, this is a conditional waiver and release on progress payment form. Now, SunRay can help you with all this. Also, you see on the lower left, it says Porter Law Group. If you go on my website, I have these forms as well, and they're free. But you may need some help, and if you feel uncomfortable with any of it, trying to do it yourself, please give Jesse or someone over at SunRay a call, and they'll help you out. Now, let's go through the form a little bit. And you can see at the top, it says what I said. It waives your lien, stop payment notice, and payment bond rights. Doesn't release contract rights, fortunately. So going through the form, you'll see the name of the claimant. That's going to be you, or it's like a potential claimant, and the name of your customer, and then what the job is and who the owner is. Now, very important, and when you see the form, it may line up a little bit different because this one is kind of long on the horizon, and it's usually like 8.5 by 11 up and down. And so the through date is very important. Here's kind of the got you of it. The through date doesn't necessarily mean your invoice date. What it means is the date through which all the materials or all the work has been performed that matches up with the $ of the check below. Okay, so the through date and the amount of the check have to match up. So if sometimes this requires you to estimate to the end of the month for the through date, because some companies, some contractors will want you to use a particular date, so you have to estimate. But otherwise, if you have a through date, you have to look at all the work that you did up to that date and all the materials that you supplied, and then how much the bill for those would be. And it's okay to estimate into the future. And then you put who writes the check and who the check is payable to you, generally you. And then there's a note down here on the exceptions, okay? It doesn't include retentions, so you don't want to put that in your dollar amount. Those are dealt with separately. And then there's something in number 2, extras. And that could be, it's kind of vague, but it's what the statute says. And it could be things that are like change orders that haven't been executed, or things that have been confirmed through some other means like emails and all that. And they're just like vague. That's a break for you. I view it. It's some vague thing that's an extra. That oh yeah, they wanted me to put in this extra I don't know, outdoor sink or something. I don't have a change order for it, but there it is. I did it, and it's not part of our scope, and so I got to work that out still. So that's yet to be worked out. Okay, and then also number 3 is really important. And so if you have multiple conditional waiver and releases on progress payments, because there are multiple progress payments, and maybe you didn't get paid for the one before, you deal with it number 3, because perhaps last month, let's say you filled out one of these and it was for $20,000, and then the check didn't come in yet, and now there's another one, and this month you have $25,000. So how much should this one be? Should it be the 25 you're owed now? But you're saying you're giving up all your rights through a certain date for a certain amount of money. So therefore, should you make it the 25 plus the 20 more, like 45? So what you do is you make this second one here for 25 just for this month, but then down on number 3, you note that, let's say last month, and you put the amount in and the date in for last month down here, and you say, hey, I got a 25,000 one here now from above, but I didn't get the one last month. So then if you include the part you filled out above and the part you filled out below that says you haven't gotten your check from last month, then that should equal what you were owed to this point. Okay, then you sign it and give your title and the date, and then you send it. Sometimes people want you to sign these before a notary, and if you want to push back on that, that's fine, because the statute does not require it. And you can say, hey, there's part of the statute, if you look at it, it says you're not supposed to change anything. Well, I kind of view requiring you to notarize it as kind of a change in what is allowed under the law. So you could push back on that. But on the other hand, you should probably have someone in your office that has the ability, is licensed to be a notary. It's a pretty easy thing to do. And we have 2 people here that are notaries, and so it's just handy to have. It might be something you think about. Anyway, now we're on the final payments, and thank you, Jesse. Here's one for the final payment. It says the same thing at the top, and then the name of the claimant, the name of the customer, the job location, and the owner, and then here's the conditional waiver and release, and it's getting more simple because there's not, now we're just, all we have is the conditional and then the unconditional on final payment, and then you get a check for this amount payable to, and then basically sometimes you just get to this point, and if the check clears the bank, you're done because the condition has been met. But there is something to note on this, and it's important for you because you could do a gotcha on yourself by not noting something down here. Let's say you have a disputed issue. Let's say change order number 6 is in dispute, and maybe the GC or the owner says, this is part of your scope. We don't think it should be a change order, and you disagree. So down here you could write in a dollar amount, let's say $12,580 regarding disputed change order number 6. That's what you could put there. That means you would release everything for the amount of the check, and you would still have this one issue down here that is yet to resolve. So you don't release anything as to that. If the check is truly your final check and you don't have any issues in dispute, then you probably want to put down there where the dollar sign is just a 0 or ZERO, and let it go at that. And then that may be the end. Although it may be just to be certain, and maybe the owner wants it to be certain that the check has cleared, they may want the unconditional. So let's look at that one. It's the next one. And so this is the one that basically the granddaddy that they all want. Okay, same thing on the top. You identify yourself and the owner. You still have these exceptions down here. It doesn't affect any of the following. If you have disputed issues, you can give up everything and get paid and unconditionally waive and release anything. And then that way, the owner is going to know that, okay, everything is released and they have been paid, but there are some issues down here at the bottom. Okay, there's disputed claims for extras in the amount of whatever it is. Form, then you sign it. and then except for the disputed issues, you have given up everything. Now, as I noted before, if the case is that you made a mistake on any of these or all of these, and someone is pushing you on this and saying, oh, you released things and you can't do anything now, don't forget, you still can sue for breach of contract. And then there are other things that you can sue for too. You can sue for things like the benefit conferred. You can sue for misrepresentation. You can sue for just about anything except for mechanics lien, stop payment notice, and payment bond claim. The goal of a lot of these is to protect the owner. And so the owner is relying on these. And also, like the owner, because it's a part of the owner group, is lenders. And so they want to be sure that you don't have the right to come back with a mechanics lien and sell the property. Now, if you have a dispute with whoever's supposed to be paying you, they're not in that equation. And so for that reason, you can still sue whoever owes you the money for things like breach of contract and all that. So it is best to always do this right, but if you don't, you can come back to those things. Now, if any of you, any difficulty, or you have any questions, I would be very happy to consider it a part of this seminar if you would give me a call or email me. And you can find, well, my email address is right there. It's on the first screen. It's bporter@porterlaw.com. You can, and there it is. Thanks, Jesse. You can email me, or you can give me a call and say, hey, I didn't understand something from the seminar today, and then I will be happy to talk to you. Okay? You could call me today or any time in the next couple of weeks, but since I did the webinar today, it would be best to get a hold of me. So try to get a hold of me between now and a week from today. Okay? Jesse, are there any questions that?
Yes. First of all, Bill, you really are incredible. Thank you so much for that webinar. But if anybody does think of any questions in the meantime and you can't get a hold of Bill, always reach out to me. I'll do my very best to help you. As far as the questions that have come through, there are a couple that have come through.
Okay.
The first one, it says, can I lien and collect the entire unpaid amount from the property owner if they have already paid the GC in full?
And then the GC didn't pay you? I would assume. Absolutely. That's the point of it all, that you can do that. And what is going to happen when you do that? It may be that the owner will have to pay you to protect their property from being sold, or they may have to go get a bond. But most likely, the first thing they're going to do is get a hold of the general contractor, if you're a sub, and say, hey, GC, I paid you. What the heck? Why didn't you pay your subcontractor? And it could be because they use money for other purposes, or it could be because there's a dispute regarding your work or some other issue that is stopping them from paying you. In California, just so you know, if a GC has a dispute with a subcontractor, the GC under law is allowed to withhold 150%, like 1.5 times the amount in dispute until it gets resolved. Okay, so that may be an issue, but yeah, certainly, if the GC gets paid and they don't pay you, you're going after the owner and their property. Also, the GC could file bankruptcy, but you would still be able to go after the owner on a mechanics lien. Absolutely.
All right, thank you. Another question that has come through says, can I add pending change orders that have not yet been approved to the disputed amounts on a conditional final?
On a conditional final, yeah, I would say that you can. When you're going to do a conditional final, what you are saying is, if I get a check for this amount, then I am made whole and I'm happy. And you may have done some extra work, and it may be, let's say the foreman said, hey, I need you to do this, and you said, it's not my scope. And then he says, I'm giving you a directive to do it anyway. We'll work out the price later, and if there's any extra days of overhead, that type of thing, we'll work it out later. And then they come back to you and says, hey, we're not going to grant it. Well, that's a disputed issue, but you have to put in everything that you think that you are owed on the amount of money that you're owed. So some stuff, I would say, if you're going to put in a change order, you should be able to at the end, you're going to put in your lien, you should be able to put it in your final releases, the conditional and unconditional release, because what you're saying is, I will not be happy and made whole until this is the amount I get. Now, it may be that you have to negotiate that and work it down, but if you start from a position of leaving off things because they're not fully signed, then you're going to be starting off from a position of weakness. And if you, in good faith, truly believe that you are owed those sums, and this is the issue, then you should put it in there. Now, there is something I should add, and it's something that we do in another seminar. If you intentionally later on inflate your mechanics lien, not in good faith, then the penalty can be severe. So you have to weigh this. The severe penalty is that you could lose your entire lien and not just the part that is maybe overstated or in dispute. So when you get to that stage, you have to be able to say, yes, in good faith, I believe I am owed this amount. This is the amount I'm putting in my unconditional on final and conditional on final, and this is later on the amount I'm going to put into my mechanics lien or my stop payment notice or my payment bond claim. But it has to be in good faith. And the good faith should be something that you should be able to prove through documents and things. So that's why it's important too to document issues as they come up. And emails are often very important to this, saying things like, hey, our price for this extra work, which we consider to be out of scope, is X dollars. Please send us a change order form, and just document it. And then you might even say things in it like if you disagree in any way with what I have stated in this and the figure I have arrived at, please respond to me in the next 2 work days in writing, stating the nature of your disagreement and what you would propose to the contrary. Something like that. Put it back on them. Then when you go to court later, the judge will look at the emails and he will say, well, we see that you, Mr. Subcontractor, you put this into your email, and we see that Mr. GC, you didn't respond. So the implication is, Mr. GC, that you didn't have a response because you didn't disagree at the time, and now you do. And so I'm going to go with the subcontractor on this issue because, Mr. GC, you should have responded. So you have to play the paper game too when you get to that stage. I went a little bit off track on the question, but I hope the extra info was helpful.
Of course, that's very helpful. Okay, another question that came through that's kind of on that same thought process. It says, what happens if you send your GC a conditional final, and before you get paid, they send you a change order? Do you just send them a revised conditional final? What is to stop them from using the original conditional final?
Well, the timing of the things, hopefully you'll be able to show that. I would say that immediately you should do a revised one, because something has to happen. Something has come to you, and so if you don't do something, then you will be blamed for it. But what I would do is I would do an email back and say, even though the other day I sent the release, this change order has come through, and therefore I am amending the release so that it's fully updated. Thank you very much. Something like that. But keep the paperwork up to date and accurate, so somebody isn't able to later say, why didn't you say something? And everything should be in writing. It doesn't mean it has to be very formal and all that, but emails are really handy. Could you imagine doing things before emails and electronic communications existed? I'm old enough to remember that. So maybe some of you are too. The curly fax paper that would come out like 150 degrees and curl up on your floor. Yeah, but now it's convenient. So use that convenience. It's in the palm of your hand, isn't it? So use that. All right. Well, perfect. Thank you so much for all of those tips. I think that is all the questions that have come through. If anyone does think of another question that wasn't addressed, please feel free to reach out and we'll be sure to answer any questions for you. As Bill said, he is going on his much deserved vacation. So if you guys do have something in that time frame, please reach out to me and we will do our very best to help answer that or get you in touch with somebody else from his office if need be. All right. Well, it's been a pleasure helping you all out today. Yes, thank you.
All right, so our next webinar with Bill is going to be Thursday, August 6th. And that's going to be what happens after I record my lien, how do I get paid? And then we have another one that's going to be in November. We'd love to be able to see you guys there. Please go ahead and sign up for free at sunraynotice.com/education so we can make sure that we can get that content to you. All right, here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. Today's webinar was specifically about California lien law. If you are working in a neighboring state or somewhere different, please know that every state has unique deadlines, unique documents and requirements. So please, please, please go onto our website. You can put in there what state you're working in, what type of job it is, what your role is, and it will kind of tell you exactly what those documents are and what those time frames. So please check that out. All right, and let me see here. All right, if you don't mind, give us a quick moment of your time. You can go scan this QR code and give us a little bit of feedback. We really do appreciate it. Any of your feedback, it always helps us better ourselves and our content for future webinars. So please, if you don't mind, give us a minute of your time. All right, and with that, that is all I have for you guys today. Thank you so much to everybody who attended. We hope to see you guys at our next webinar. Again, Bill, you really are wonderful. Thank you so much. I hope everyone has a beautiful and wonderful sunny day. Thanks, everyone.